Thank you, Mr. Chief Justice, and may it please the court. I'm Jake Warner here on behalf of
Hey friends, thanks for
petitioners
joining us
Dr.
this morning.
Eric
Right now we are
Hazelrig
listening in
and
on
Yavapai
oral arguments starting in
County
the
Attorney.
Supreme Court, Arizona Supreme
For over
Court right now for
100
Planned
years,
Parenthood
Arizona has
versus
fully
Kristen Mays. It
protected
is, of
human
course,
life
the
from the
abortion
moment of
decision that will be made
conception.
today for the state of
In
Arizona. So we're going to go ahead and
1973,
listen
Roe
in and
v.
then
Wade
give you guys a
temporarily
recap at the
stopped
end.
that protection. That mistake put Arizona in a bind. Had the legislature done nothing, unborn life would have been fully unprotected, all the way up to birth, for 50 years. That was unconscionable. So the legislature reenacted Section 133603 to fully protect unborn life, except to save the mother. And it passed supplemental protections, carefully saying these laws did not repeal Section 133603.
But Mr. Warner, that didn't actually occur right away. Nothing happened after 1973, absent a statute, I think, that said that physicians don't have to perform abortions. But then it just pretty much meandered along into the late 90s with a ban of partial abortion, and then a ban in 2000 with post-viability, with none of the language that you're citing that kind of came into existence around 2010 with the first 20-week limitation. So is that accurate, that up until 2010, there was no language and no indication in any of these laws that the legislature intended that 133603 be applicable?
I don't believe so, Your Honor, because in the 1970s, in fact in 1977, the legislature reenacted Section 13-3603, and it carefully enacted supplemental protections all along the way, saying that these supplemental protections created no right to an abortion, that they legalized no currently unlawful abortion, and then, of course, most recently, just last year, the legislature reaffirmed Section 13-3603, saying that SB 1164 does not repeal that law.
Are you asking the court, however, to effectively say that with the decision in Dobbs, that effectively all of the Title 36 provisions restricting abortion, regulating abortion, causing the Department of Health Services to enact rules and such are now effectively nullified?
Absolutely not, Your Honor. In fact, in our view, we believe all those regulations are fully applicable, and I'm happy to walk through with the court how all these laws fit together post-Roe.
Why don't you start with 362322?
Yes, Your Honor. Starting with Section 362322, that law is otherwise known as the 15 weeks law, and it requires that after 15 weeks that determination be immediately necessary to either preserve the mother's life or to prevent significant and irreversible bodily impairment. So if we pair that with the pre-Roe law, which is Section 13-3603, here's the straightforward way that all these laws fit together. Up to 15 weeks, the termination must be life-saving. After 15 weeks, the termination must be immediately necessary to either save the woman's life or to prevent significant and irreversible bodily impairment. There's an immediacy requirement that kicks in at 15 weeks, and for good reason. The state has a growing interest in protecting unborn children. So at 15 weeks, they apply this additional requirement, which requires that the termination not only be life-saving, but immediately necessary to preserve the mom's life and to prevent significant and irreversible bodily impairment.
So the 15-week ban is in effect?
It's fully applicable alongside the pre-Roe law, Your Honor, because of that immediacy requirement. There's a timing requirement in the 15 weeks law that's simply not present in the pre-Roe law. To satisfy the pre-Roe law, the termination need only be life-saving. But not all life-saving terminations are emergencies.
And you say it must be life-saving because of the language of 133603?
Yes, Your Honor. So if you're reading these laws together, Section 13-3603 requires that the termination be life-saving. But not all life-saving terminations are immediately required. For example, there are certain cancer treatments that could wait a week or a month or even a couple of months, or certain cardiomyopathies that might not require an immediate termination. So after 15 weeks, the state adds an additional protection for unborn life. It says that the termination must not only be life-saving to agree with Section 13-3603, but it must be immediately necessary to either preserve the mother's life or to prevent significant and irreversible bodily impairment.
I'm still a bit confused about how 2322 works. if you represented a physician, the physician came to you and asked you, may I legally, in the state of Arizona, perform an abortion if I've determined that the gestational stage for the fetus is less than 15 weeks, would your answer be yes or no?
If determination is life-saving, there is no problem under Arizona law if it's before 15 weeks.
It has to be life-saving, though, because of 3603.
Correct, Your Honor. The legislature created Section 13-3603 to ensure that any termination before 15 weeks is life-saving. The 15 weeks law kicks in at 15 weeks to add the additional requirement that determination be immediately necessary to protect the mother's
So if I
life.
understand you correctly, we're not arguing about whether the legislature modified 3603 when it passed 362322. We're simply arguing what that modification was.
Exactly. It's like any other regulation in Title 36, Your Honor. It adds an additional immediacy requirement that the original law never had. And it makes good sense because as we've learned over the past 50 years, the science has shown that the viability line for unborn children keeps going down and down. And once that 15 weeks law kicks in, there's an additional protection for unborn life, ensuring that the termination must be immediately necessary to either protect the mother's life or to prevent significant and irreversible bodily impairment. And this is to say nothing of the construction directives, which should control this entire argument.
Well, let's look at the intent directive instead. I would, if indeed the intent was to do as you were saying, I would expect to find that in the intent section. Instead, what I find is the following language. The legislature intends through this act to restrict the practice of non-therapeutic or elective abortion to the period up to 15 weeks of gestation. What I hear you saying is there is no such thing as elective abortion. So how do we follow the intent that the legislature actually told us to follow?
Yes, Justice Bollock. I believe in that same provision that you just cited, it talks about what this act, what SB 1164 was doing. And of course, it does not pretend to regulate any termination before 15 weeks. That's what Section 13-3603 does. But that purpose language accurately reflects that the legislature was enacting this law in the context of Roe. Roe allowed certain abortions, and the legislature was basically setting the limit for permissible abortions here in Arizona. So that purpose statement really does nothing more than acknowledge what the effect of Roe was and say, look, we're coming in and we're issuing the ceiling to this law.
Doesn't it also suggest that the language in 362322B, when read in light of the legislative intent in Section 3B of the initiative, is referring to non-therapeutic or elective abortions and not to abortions that are necessary to preserve the mother's health?
I don't believe so, Your Honor. That provision, it only purports to regulate terminations after 15 weeks based on its language. It does not regulate terminations before 15 weeks. In fact, the statute is silent as to terminations before 15 weeks. The absence of regulation in Section 36-2322 does not preclude the legislature from further regulating abortion in other statutes, including Section 13-3603.
What about 362301.01, which is the one that was enacted since 2000 and is still on the books? It's never been repealed, but it says that a physician shall not perform an abortion post-viability, but it's okay pre-viability.
Yes, Your Honor.
What's the status of that?
Of course, I believe it can be fully applied alongside Section 13-3603. So once the unborn child reaches the age of viability, the provision you mentioned, the viability law, kicks in to ensure that whatever procedure that the physician provides, it's going to protect the unborn child. There is no conflict between the viability law and Section 13-3603. That provision does not allow any termination that Section 13-3603 forbids. And I want to address the construction directives because I think that they are critical to understanding how these laws fit together. First, SB 1164 says Title 36 does not repeal Section 13-3603. Repeals can be full or partial, and they occur even when the law's scope is limited. Under the interpretive direction canon, Title 36 cannot limit Section 13-3603, and other canons cannot reverse this priority because the legislature has expressly given this priority in its construction section. Second, Title 36 creates no right to an abortion. The legislature did not say fundamental right, constitutional right, or any other kind of right. It's just talking about a plain old right.
But
And a
do you
right.
need to give the woman a right to an abortion in order for the legislature to decide we're going to restrict who we're going to prosecute for performing abortions?
Well, Your Honor, I would say under respondents' view, every outcome ensures that either the woman or the physician has a right to perform an abortion. And it creates a right three different ways. First, it creates a statutory right to an abortion because under respondents' view, Title 36 expressly permits terminations before 15 weeks by statute. Second, it creates a negative right to an abortion. It ensures that the government cannot apply Section 13-3603 to regulate physicians, and it creates a conditional right to an abortion, ensuring that if physicians complete the requirements of Title 36, they can complete a termination before 15 weeks. The legislature intended none of this by design by saying that Title 36 creates no right to an abortion. Third, Title 36 legalizes no currently unlawful abortion. And to be fair, I think this provision could be read two ways. It could be read to suggest that this law legalizes no currently unlawful abortion at the time that the act was created. That's one view. I think the better read, though, is that this provision is directing courts how to construe the law at the time that they are asked to interpret it. They're saying this law legalizes no currently unlawful abortion. And in context, it comes underneath the construction section in the statute. So the legislature is telling courts this is how you should construe
At the
this
time
law.
this was passed, abortion up through the second trimester was effectively legal because of the decision in Rowan and Casey. Is that what it's referring to? So really, there was certainly a broad permission for abortion in the state of Arizona at the time this was passed. Is that what the currently unlawful means?
I don't think so, Your Honor. And I think in context,
Does it mean unlawful except for the United States Supreme Court?
I think what this provision is getting at is when it says that Title 36 legalizes no currently unlawful abortion, it's talking about currently at the time when the law is being interpreted. We often talk about current or currently in this situation.
So it's current in light of what happens in the future.
Well, for example, Your Honor, if I said...
That seems like an unreasonable reading to me.
Well, let me try to persuade you, Your Honor. So we often use current or currently even when referring to future conduct. For example, if I say use the current password next month, I'm not saying use the password that's going to work today. I'm saying use the one that's going to be in place next month. Or another way of saying it is use the password that's currently applicable next month. And I think in context, this really gives this provision meaning because over the past 50 years, the legislature is creating increasingly pro-life laws. And if they're saying that this law legalizes no currently unlawful abortion, it's not really going to have much meaning if the laws are getting stricter and stricter in this context. So
Couldn't they have simply said, been a little clearer for all of us, and said that if Roe versus Wade is overruled, that in that case, this the 133603 will take place, or in the next legislative session after the Dobbs decision, simply do just that.
Your Honor, we could certainly...
Oh, I'm sorry, go ahead.
Your Honor, we could certainly debate the art of these provisions, but I do believe the grammar is sound. What the legislature did give us is that it said, look, this 15 weeks law, it doesn't repeal Section 13-3603. It creates no right to an abortion, and it legalizes no currently unlawful abortion. Could the legislature has
So what was the point of it? Why pass this?
Well,
If it didn't do anything, why?
Well, two responses, Your Honor. Of course, at the time that the legislature passed the 15 weeks law, the Roe v. Wade decision was in full effect. So they were legislating against the...
In fact, they hoped what would happen was that Dobbs would come down and find the Mississippi law to be constitutional.
They were certainly legislating in the context of what was happening in Mississippi, but they didn't mirror everything that Mississippi did. Arizona is certainly free to use its own words to accomplish its own objectives, which is what it did here. And like I mentioned earlier, the 15 weeks law still has tremendous meaning even after the injunction below is lifted. That's because it adds an additional requirement onto Section 13-3603 in requiring that determination not only be life-saving, but immediately necessary.
In fact, if Dobbs had come down the way they anticipated, what they intended was this statute would make abortion possible up to 15 weeks in the state of Arizona, elective abortion.
Well, Your Honor-
That's why they passed this, isn't it?
Well, Your Honor, we can debate the legislative intent here, but I believe the legislative text is clear. What the legislature did is that it created an additional requirement on top of Section 13-3603. Up to 15 weeks, the termination must be life-saving based on the pre-Roe law. After 15 weeks, the termination must also be immediately necessary to protect the mother's life or to prevent significant and irreversible.
And the point I'm trying to make with you is I think that if in fact Dobbs had done what the legislature intended, that would not be the argument you'd be making. You'd be making this as constitutional because it allows an elective right to abortion up until 15 weeks. But what I'm suggesting to you is what it looks to me like is their intent was to create a statute that would accomplish that.
Well,
And
Your
they
Honor-
just got more than they asked for.
Well, I think they were legislating understanding that multiple outcomes were in place. Certainly if Roe stayed the legislature's hand and they could not fully imply all the laws that they passed over the past 50 years or even 100 years, that's one thing. But what the legislature did was it ensured that if the Dobbs decision was a win, whether the court simply upheld the 15 weeks law or whether it went the whole way and reversed Roe, that unborn life would be protected to the greatest extent possible here in the state of Arizona.
Well,
Now,
and at the time that 2322 was passed, you previously had the 20-week limit. Now you have the 15-week limit. The 20-week limit had been declared unconstitutional by the Ninth Circuit under the Isaacson case. So assumingly that the 15-week ban or limit was already unconstitutional as soon as it was passed, accepting Dobbs. Is that accurate?
I don't believe there was any injunction forbidding the enforcement of the 15 weeks law. Certainly if it were challenged, the Isaacson
Right.
decision could be
There was
persuasive.
no order in place, but if the 20-week wasn't going to fly with the Ninth Circuit, neither was the 15-week, obviously.
And I think this certainly illustrates that the legislature was doing the best it could to protect life at every stage along the way. If Roe fell, then certainly the old pre-Roe law, the Section 13-3603, could be revived simply with a lifting of the injunction, which is obviously what we're here today asking this court to do.
And the reason I raised it was, doesn't that feed into what the chief was just saying, that what the part of the context that was occurring here was hopefully the Dobbs decision, the legislature had hoped would overturn essentially, effectively, the Isaacson decision and allow a 15-week limit in place.
Yeah, I don't think the legislature precluded the possibility of the U.S. Supreme Court also overturning Roe. That's why SB 1164 said, look, we're not repealing our pre-Roe law, Section 13-3603. So it wasn't as if that outcome was uncontemplated just by the very text in the statute. And indeed, after Roe fell, all these laws fit together perfectly. Up to 15 weeks, the termination must be life-saving. After 15 weeks, the termination must be both life-saving and immediately necessary.
So, taking the chief's question in a different direction, let's say that Roe had not been overturned, but the 15-week limit was sustained there. Then obviously our law would have been in operation, and if a physician complied with that law, the physician could not be prosecuted, right?
Correct.
So I don't understand then how that law is not in conflict with the territorial ban if something that could not be prosecuted now can be prosecuted.
Well, Your Honor, I would say that these laws can be read together. This court should certainly construe all the text together to the extent it can. I don't believe there's a conflict, and I'll come back to that if this court disagrees with me on that. But I believe the fair reading of the 15 weeks law is that it creates an additional requirement on top of Section 13-3603. It's like adding a physician-only surgeries requirement or a physician-only drugs requirement. You can further regulate conduct in addition to Section 13-3603 without there being a conflict, and that's what the 15 weeks law 15 weeks law does. After 15 weeks, the termination must not only be life-saving based on the pre-Roe law, it must be immediately necessary, so there's an urgency
But to be
requirement.
clear, in response to Justice Bullock's question, if it had occurred as his hypothetical suggests, the physician could not have been prosecuted, because otherwise it wouldn't have been constitutional. The physician couldn't have been prosecuted for performing an elective abortion up to 15 weeks, correct?
Yes, but that's only because of the pre-Roe law being enjoined.
But it's also because of the language of this statute.
I don't believe so, Your Honor. If we look at the language of the statute, it only purports to regulate terminations after 15 weeks. It in no way purports to regulate terminations before 15 weeks. And I think that was on purpose because the legislature said that nothing in that law was meant to repeal Section 13-3603.
If the Supreme Court in Dobbs had upheld a federal constitutional right to an abortion up until 15 weeks, would there be any need or purpose for the legislature to statutorily recognize that right?
There would be no need for the legislature to recognize it because the U.S. Supreme Court has said it's there. But certainly they are legislating against the backdrop of the law as they know it. This court obviously presumes that legislatures know applicable laws at the time that it is enacting its statutes. Yes, Your Honor. I also want to quickly talk about how the additional Title 36 regulations fit in with and apply alongside the Section 13-3603. Obviously, the gestational age requirement is still applicable because physicians need to know when the immediacy requirement of the 15 weeks law kicks in. That's why they need to determine whether the termination is at or before 15 weeks. And then respondents talk about a host of informed consent laws and notices and ultrasound rules. All of those apply in cases that are not emergencies. Of course, not every life-saving termination is an emergency. So for those life-saving terminations, those laws would fully apply without incident. And the reporting requirements have been discussed by the parties. Of course, life-saving terminations are fully reportable events. Nothing will prevent physicians or hospitals from complying with their reporting duties if the injunction below is lifted. Then we have the reason law, which is Section 13-3603.02. It also applies unless there is an emergency. Not every life-saving termination is an emergency, so that law retains its full vitality.
Mr. Warner, so if an abortion is performed, say at week 17, and a physician performs an abortion, that would be a violation of 13-3603, and there's no life-saving involved. It's just an elective abortion after that time. Would that be a violation of both the criminal statute and 36-2322?
So the termination is at 17 weeks, as I understand it. It's not life-saving, so it would not. It would violate the pre-Roe law, Section 13-3603, and to satisfy the 15 weeks law, the termination would need to be immediately necessary to protect the mother's life or prevent significant and irreversible bodily impairment.
So under that scenario, it would violate both statutes.
If it was not immediately necessary, as I understand your hypothetical, Your Honor, that's correct.
And of course, I'm getting to the next question, which is, but there are different criminal penalties under each of those provisions. So it's a 2 to 5 year imprisonment term under what we've been calling the territorial law, and then it's a class 5 felony, or class 5 felony, which is a different punishment. So what do we do with that conflict?
Well, as I understand it, the parties do not dispute that these laws regulate separate offenses. Of course, other law would kick in and ensure that that the prosecutors would have discretion to choose, just like they would have discretion to choose under any other law, which that they were going to prosecute under, depending on if the elements were satisfied.
Does that a due process problem for notifying physicians of the potential consequence of violating the law if you're depending on, 15 different county attorneys' discretion on under which law that they will prosecute?
Well, county attorneys, the legislature has said that they shall prosecute offenses if they have reasonable information. So these attorneys should apply the law. They should faithfully try to apply the law. But to the extent that we have individual county attorneys declining to prosecute the law, the fact of uncertain enforcement doesn't make the law unenforceable. There's nothing unclear about the law itself. Another way of saying it is that there's nothing uncertain about the law, and if there's uncertain enforcement, that means that county attorneys should apply the law as given, consistent with their statutory duties. I see my time is about up for opening argument. Unless there are other questions at this time, I'd like to reserve the balance of my time for rebuttal.
Very well. Mr. Gaona.
Good morning, Your Honors. May it please the Court. Andy Gaona with Coppersmith Brockelman here on behalf of Planned Parenthood Arizona. As the Attorney General's motion regarding oral argument previewed, our side has decided to try to divide our time as best we can, understanding that that may not happen as we want it to, but I will endeavor
keep track of the time.
I will endeavor to take up about 13 minutes, the Solicitor General 12, and the Pima County Attorney the balance, which would be 5 minutes. I want to take a step back for a moment to put this case into some context. 50 years ago, when the Court of Appeals declared the territorial ban unconstitutional as to all, that was the only regulation of abortion on the books in Arizona. Since then, the legislature has enacted dozens of statutes that prescribe the who, the how, and, as relevant here, the when of that important healthcare procedure. But never once in that half century of legislating did the legislature ever signal any intent that most, if not all, of those subsequent enactments would become mere empty shells if Roe versus Wade were ever to fall. And the legislature could very easily have done so. As the parties have briefed extensively.
So address Mr. Weller's point in response to Justice Lopez's question. I mean, what was the purpose of this if it wasn't simply to put a cap on when an elective abortion could occur in the event the U.S. Supreme Court made that constitutional?
I agree that the point was to alter the permissions for when an abortion could occur if the Supreme Court had moderated itself, for example, and not overturned Roe versus Wade, but had upheld Mississippi's law. And so I do agree that that was the point. And I think that gets to a lot of the questions that we discussed here, that as we went from what was a viability law to the 20-week law that was ultimately enjoined to the 15-week law, what you saw was the legislature changing the conduct that was permitted and how abortions could be performed, who they could be performed by, and when they could be performed.
Under the auspices of Roe.
That's correct, Your Honor.
So where in Title 36 is there a freestanding right to an abortion?
Your Honor, we have never maintained that there's a freestanding right to abortion in Title 36, nor does
That genesis of that right came from Roe.
that's the
Roe Casey.
we fully concede that the legislature was at this time was legislating against the backdrop of Roe. But the interveners have said, well, because in the construction provision, the legislature disclaimed the creation of any right and cite a definition of a Black's Law definition of the word right, QED, they win. But that's not how criminal laws work. Criminal laws permit, authorize, allow, whatever you want to say, that which they do not criminalize. And here in the specific context of abortion and in the specific context of the 15-week law, the Arizona legislature said physicians can perform abortions up to 15 weeks LMP, and they cannot be prosecuted for that. And I heard Mr. Warner agree that had the law gone fully into effect, that was the law. That's the law as we sit here right now under the Court of Appeals decision.
Does the legislature need to declare a right for a woman to have an abortion in order to decide to limit the circumstances in which a physician may be prosecuted for performing an abortion?
Absolutely not, Your Honor. The legislature need only regulate conduct through the criminal code. It does it all the time. If a statute says that the speed limit is 45, I don't have a freestanding right to drive at 35 miles per hour. I can't be prosecuted as a function of due process, of course, but I don't have a right to do that. And I think this illustrates itself well if you consider a world, again, in which the U.S. Supreme Court had not overturned Roe versus Wade. We still have Roe in the background, but we have the 15-week law. We wouldn't say that physicians have a freestanding statutory right to perform abortions under that framework. We wouldn't say they have a statutory right. We would say that it is legal for an abortion to be performed in that context, the same way that it is legal for me to drive 35 if the speed limit is 45, but I don't have a freestanding right to do it, nor does the legislature have to create one. So I think the focus on whether or not a right is created is a complete red herring.
Conceding that point, there's other language that appears to be more problematic. The legislature does not intend this act to make unlawful an abortion that is currently unlawful, or to make lawful an abortion that is currently unlawful, and it also specifically references the territorial law and says that it's not repealed by implication or otherwise. What does that all mean?
So I think there's a couple questions in there, Your Honor, so let me try to address them in order. So with respect to currently unlawful, I disagree with Mr. Warner about the time in which we have to look at currently. Currently means the world in which the legislature was enacting that statute and when the bill was enrolled.
What about ARS 1, Section 1-214 that provides that words in the present tense include the future as well as the present?
I think there's a couple responses to that, Your Honor. The first is that currently is not a verb, so it doesn't really have a tense in the traditional sense. So I'm not sure we can apply that particular statutory construction piece to that. But the other thing is there's a perfectly valid explanation for that exists completely outside of this, which is that there are a host of other statutes that continue to limit the abortions that physicians can perform in Arizona. Mr. Warner mentioned one of them, and perhaps the biggest one that's been in the discourse in the reproductive rights space, which is what has been called the reason ban. There's a separate statute within Title 36 that bars physicians from performing elective abortions if they know that it is for certain prohibited reasons. So I think what the legislature was doing there was signaling that when we are enacting this revised permission for physicians, we are not intending to repeal the prohibitions we placed earlier on physicians, which would include the reason ban, for example. So I think that's how you can fairly easily deal with the currently language. As to the not wanting to, or the second part of the construction section about not wanting to repeal impliedly or otherwise 133603. But I think it's important that the statute doesn't just say that. It says 133603 or any other statute regulating abortion. And so on that point, I would say two things. The first is that, to take the second part, to adopt the intervener's view and construction of the statute would in fact actually impliedly repeal scores of statutes because they would become useless and unenforceable. I think one of the amici on their side said that some laws, to be sure, some laws may get dusty, which I appreciate as a writer, but it's a very clever way to say that they will be unenforceable and in fact impliedly repealed. The second thing I would say is that by harmonizing the statutes as the Court of Appeals did, the statutes being the territorial ban and the 15-week law, nothing has been repealed, either fully or partially. The ARS 133603 remains on the books today. It's never come off the books. And we concede, Planned Parenthood conceded below, that the injunction should be lifted, in part, such that 133603 could be enforced against non-physicians. We agree with that. That is a statute that can be enforced is definitionally not repealed.
Would it be enforceable against physicians past 15 weeks as long as it was an elective abortion?
No, Your Honor. We believe that in enacting the 15-week law, that is now the criminal prohibition for physicians who commit elective abortions outside of the scope of that law. What I would say further on this repeal point, because this, I think, is the two primary arguments that interveners now rest on, and which have been some.
Let me make sure I understand
Sure.
before you move on. So you're saying a physician that performed an elective abortion after 15 weeks couldn't be prosecuted under the territorial statute, but could be prosecuted under the new statute 2322.
Correct, Your Honor.
Okay, I understand. Thank you.
And on this point of implied repeal, I would say one other thing, which is that this court has drawn a distinction in its case law. The most recent example I could find was in the Cave Creek versus Ducey case, which I think was 2013, about what you do when there are statutes that appear to conflict, that there is a difference between implied repeal and implied amendments. And so this is where I think looking at the construction provision of SB 1164 is important, because what it says is that the legislature is not intending to repeal impliedly or otherwise 133603 or any other statute. It does not, as Mr. Warner got up here and just told you, it does not say anything about limiting. It does not say anything about impliedly amending. And I think that is if we are looking to what actually happened here, when you have a series of statutes that are not self-referential, that don't necessarily say we're repealing an old permission, we're just putting something else on top of it. What you have in effect is an implied repeal, and that's okay. And in fact, this court, in citing an example of an implied repeal that was perfectly okay, cited a case called Reeser, which is, and I will give you the quote here because I don't believe any party has cited it before, but it's 109 Arizona 473, excuse me. And there you had an old statute, there was a tax statute, the most exciting kind, of course. You had an old tax statute and a new tax statute. There were differences between them. And this court ultimately said, we find that the newer enactment impliedly impliedly amended the older enactment. And we read those things in harmony. And the court's language there is that those two statutes, quote, should be read and considered together, and both should be given effect where possible. That's exactly what the Court of Appeals did. That's exactly what we are asking this court to do with respect to the territorial ban.
How do you respond, though, to Mr. Warner's point that he can read them together as well? He simply says that past 15 weeks, there's the additional added requirement that you show that that is immediately necessary to save the woman's life, and so that can work in harmony with 133603.
But I think the problem, Your Honor, is that construction would, in fact, impliedly repeal an entire subsection of 2322. And the legislature, when enacting this, was surely it wasn't intending to do nothing if Roe versus Wade were to fall, or even if Dobbs had come out the way everybody thought it might, which was to uphold the Mississippi law. And I think in this context, if we are looking not to operative law, but to session law for legislative intent, if the legislature's intent was truly that the 133603 should be resurrected in full and enforceable as to all if Roe versus Wade were to ever be overturned by the U.S. Supreme Court, I don't think it's too much to ask the legislature to state that clearly. And they clearly didn't do that. We've talked a lot about what the legislature has said in this context, but let's not forget that the governor that signed this bill into law, no fan of abortion rights, I think we could all agree on that, both pre-Dobbs and post-Dobbs stated his belief and his understanding that the 15-week law would be the law of the land regardless of what happened with Roe versus Wade. There was a problem here. The legislature could have fixed this up front, as the Vice Chief Justice pointed out in one of her questions in the legislative session that came after. They could have tried to clarify it there. They didn't. The fact of the matter is the legislature did not enact a full version of Mississippi's law, which everybody agrees our 15-week law was based on, because they didn't have the votes. They left out two key sentences of the construction provision from Mississippi, and had they done that, we probably wouldn't be standing here today before you. But in effect, what the interveners are asking you to do, and what the legislature, the legislative leaders, I should say, who filed an amicus brief are asking you to do, is to impose through an opinion that which they could not secure the votes in the legislature for. This is ultimately a policy question. Should we have a total abortion ban in Arizona that is enforceable against everyone, including doctors? Well, my client has a position on that, but that is not a decision that this court should be making. And what has happened here is that decision has been thrust upon you. But what we can rest on is a well-reasoned Court of Appeals opinion that resolved this case the correct way. And we can also say that we have the backdrop of settled canons of statutory construction that resolve this case.
And to be clear, there's no doubt that in this case, whether even the 15-week ban is constitutional under Arizona's constitution, explicit privacy rights, that's not an issue in this case.
Correct, Your Honor.
Purely statutory construction.
Correct, Your Honor. And I see that my time has since expired. I'm going to try to keep this as best as I could, but I'd just like to leave the court with one thought before I sit down. And that is that abortion is health care. And I'm not sure that anyone has ever said those words in this courtroom before, so they bear repeating. Abortion is health care. And what that means is that this court's decision will have a profound impact on the ability of pregnant Arizonans to access that health care from PPAZ and other providers. Thankfully, reaching the correct decision is not difficult. As we've argued, a straightforward application of this court's precedent dictates the outcome squarely in PPAZ's favor. But of course, the only reason we're here today is because in Dobbs, the U.S. Supreme Court cast aside precedent when doing so was not necessary to decide the case before it. We urge the court not to make the same mistake. Instead, this court should affirm the opinion below and affirm that Arizonans have access to abortion up through 15 weeks LNP. Thank you, Your Honors.
Mr. Bender.
Mr. Bitter, before you start, is this a public policy choice? I don't recall seeing that in the party's briefing. I thought this was a statutory construction case.
I agree. It's a statutory interpretation case.
Thank you.
I do think that we would have expected it, that if the legislature had intended to ban abortion in the state of Arizona, they would have spoken clearly. They would not have used ambiguous construction language, which is what ultimately interveners rely upon.
But what about when the fact that when the legislature, when it drafted 362322, it did not amend or repeal 133603, it just left it alone?
It explicitly said it was not repealing, but it didn't forsake whether it was amending it. And part of what I think is important, Justice King, is that even before you got to the 15-week law, we had this whole plethora of statutes in Title 36 that create a direct conflict, as does the 15-week law, with the territorial era law. And those statutes expressly permit abortions in medical emergencies and only make sense if abortions are permitted up to a period of time. So the informed consent statutes, for example, most of their provisions don't apply in a medical emergency. So under interveners' position, they would be totally useless, all those statutes. Same with the judicial bypass statute.
Well, following up Justice King's question, I think that Mr. Gaona indicated that in harmonizing the statutes, the newer statute would become the principal, if not almost exclusive way of enforcing limits on abortions. You said something in your brief, your response to amici, that I think is very important, but I'm not sure I have any idea what it means. You said maintaining Section 133603 preserves a catch-all ban on abortions that are not permitted by Title 36 and also preserves a stricter sentencing range for prosecutors to pursue. What did you mean by that?
So if you look at the court, I think it's consistent with what the Court of Appeals said in their disposition, that 133603 can't be enforced against licensed physicians who perform abortions that comply with Title 36. By the converse, it can be enforced against licensed physicians, against people who perform abortions that don't comply with Title 36. And the penalties in 133603 are 2 to 5 years, which are substantially more than a lot of the criminal penalties that exist in the rest of Title 36. And so there is real teeth to the fact that, per Justice King's question, 133603 is not repealed. It's on the statute books. It has force and effect, but it has to be read in light of all of these later statutes that the legislature
Is your answer to Justice Bullock's question, is that in conflict with Mr. Gaona's answer to an earlier question that I asked about the same thing? And he said that for physicians, the only way to prosecute is under 362322 and the penalties there. And from what I thought I heard you say that a physician could be prosecuted under 133603 if they perform an abortion post 15 weeks that doesn't comply with the 36 restriction.
It's a very good question that you're both getting at. I think there are two very plausible ways to harmonize these statutes. One is that what remains of 133603 is it applies to non-physicians, given the extensive regulations in Title 36, and that's the one Mr. Gaona was advancing. The other is that 133603 also applies to physicians when they are acting in a manner that doesn't comply with Title 36. I think both of those are very plausible ways that the court could harmonize the statute. The Court of Appeals, honestly, was not always clear as to which of those two it was adopting. If you look at some of their earlier part of the opinion, the disposition is not totally clear. I think the court could do either of those.
So that isn't contrary to the Planned Parenthood's position?
The second interpretation is I know Mr. Gaona disagrees with, yes. I think they're both plausible, and they both give effect both to the territorial era ban and to the express permissions contained in the text of both the 15-week law and other provisions in Title 36. And the text is very important. It says that a physician can't do an abortion unless he does certain things, or except if certain things. And except and unless are words that means if you fulfill their conditions, you're allowed to do the thing that you're only allowed to do if those conditions obtain. And we see that in the Village case from the U.S. Supreme Court, which was also construing an unless clause in an abortion statute. We see that in the way our legislature has enacted other statutes, which we cite in our briefs. We see that just in the way people ordinarily use those words. They're words of authorization or permission. They're not words of right, to Justice Bean's question, but they're words of authorization and permission. And that creates an express conflict with the territorial era law that this court has to deal with through ordinary tools of harmonization, not through repeal, but ordinary tools of harmonization. And what's critical is if the legislature wanted to do what the interveners said, then they would have just included one sentence from the Mississippi law, which our 15-week law was based upon. And that sentence said, an abortion that complies with this section but violates any other state law is unlawful. They didn't include that, even though they borrowed the Mississippi law. And there are plenty of cases from this court, Welch, Boucher, making clear that when the legislature has an opportunity to adopt certain language or uses a model statute and omits language from the model statute, that omission is an important statutory choice. In addition to that, the legislature never enacted any other provision ever stating that the older, more general law, 133603, would prevail over the newer, more specific laws. And really what the interveners want is to have you turn the normal rules of statutory construction on their head, but without any enactment from the legislature telling you to do so, just based on their supposition that that's what the legislature intended. But if the legislature wanted its intent to become law, they needed to enact their intention into law, and they didn't do that. If the legislature had intended to ban abortion in this state, we would have expected it to speak clearly. We would have expected it not to use language that confused other members of the legislature, the governor who signed the bill, and who gave the hard call to this court.
Is there any authority, by the way, that suggests that the governor's expression of intention about what was meant by the law that he signed has any bearing on the interpretation? I mean, usually we're looking at legislative intent,
Sure,
and so
sure.
the idea about the governor saying anything, I just wonder, well, what's the authority for that?
I don't know if there's express authority there, but I think it's indicative of the fact that at the very best for the other side, their language is ambiguous. And if you thought the legislature was really going to make this massive policy change, you would have thought they would have been a little clear about it, so at least the governor who was signing it would have known what he was signing and would have agreed with the legislature on this critically important issue. One of the points that Mr. Warner made, and this is a more minor point, is he distinguished between life-saving abortions and abortions in medical emergencies. And he said not all life-saving abortions are emergencies. I do want to note that's contrary to what the petitioners said in their petition for review on page 10, in which they conceded that a life-saving abortion is a medical emergency. As for the issue of currently, I agree with Mr. Gaona, it's not a verb, so 1-214 doesn't apply. But 1-214, to your question, Justice Pollack, is also a presumption. That's what ARS 1-211 tells us. And the court applies that presumption unless the legislature is otherwise clear. There's not another form of currently to use. Currently means the present tense, right? And so if they're using the word currently, and as they said in that sentence, the legislature does not intend this act to make lawful an abortion that is currently unlawful, they're talking about their present intent. And so we don't need 1-214 because the words are clear on their own. I'd also point the court to its decision a couple months ago in the Avitius case, in which the court looked at the tense of statutory words to figure out what duty those words imposed. And it didn't say, well, we rebut that based on 1-214, because the court could tell that the tense of the words actually indicated the meaning of the statutes in question. In terms of the right versus permission issue, I think it is very clear that a right is very different from a statutory permission. Rights have specific legal consequences that permissions don't necessarily have, so rights can vest. Rights can trigger other legal protections, like the protection of the Equal Protection Clause or the Due Process Clause. Rights can be actionable for money damages, but here the legislature was just permitting certain conduct, which is different from a right. And I don't think anyone on this side of the aisle is contending that the 15-week law creates a statutory right to an abortion, but that doesn't tell you anything about what the 15-week law permits.
It's very tough to find a case that is similar to this one in all of American jurisprudence. But the one that seems closest to me, or at least on its surface, is the Batchelder case from the U.S. Supreme Court in 1979. And there, Congress enacted two independent gun control statutes, each enforceable on its own terms. And the court, at the end of the day, said, you know what, we're going to enforce them both. It's a matter of prosecutorial discretion on how to enforce them. And there's no due process violation, to return to a point that the Vice Chief Justice was asking about. If the law is very clear in both instances, and I doubt that you are arguing that the law is unclear in either of these statutes, but in fact, I think they're rather measures of legislative clarity, at least in so far as the text is concerned. Why is that not the lodestar that we should follow?
It's a good question, Justice Bullock, and I'll confess I haven't read that case, at least recently, so I appreciate your summary of it. What is critically different here is that the 15-week law and many of the other statutes in Title 36 contain permissions and not just additional prohibitions. That's based on the plain text. And so you have a conflict that I think, based on your description, you didn't have in the Batchelder case. There you just had several prohibitions, right? We prohibit DUI in several ways. Right? It's a different crime if your BAC is above a certain level. We can have overlapping prohibitions. The issue comes when we have a combination of permissions and prohibitions. Then we have statutory conflict. We need to do statutory harmonization. And given the basic canon that more specific and recent statutes govern to the extent of conflict over older, more general ones, I think the Court of Appeals got it right. I should yield the remainder of my time to my colleague from Pima County.
Mr. Brown, you have 3.5 minutes.
And can you break the tie between your colleagues?
I will attempt to be succinct. I'm here to speak directly to Vice Chair Timmer's point about due process. In Arizona, the law must be clear. Here, as we just mentioned, there are conflicts when we are attempting to criminalize in one law that which is permitted in another. The Court of Appeals interpretation here makes the law clear. Doctors can provide an abortion before 15 weeks or in a medical emergency.
I hate to ask this threshold question, but where is the rule that Arizona law must be clear?
That is a great point.
I think that's rhetorical.
I was actually hoping there was an answer to it.
We have searched. In Hayes, the court found that when interpreting statutes, we assume our legislature has enacted them to avoid unconstitutional results. Due process requires that laws make sense to ordinary people. What the intervener has argued to you is that due process problem is resolved at the back end when prosecutors are making decisions. We submit to you that process needs to be addressed at the front end. People need to be on notice of what's prohibited, what's illegal, and leaving it to the back end doesn't solve the constitutional problem.
But as Mr. Warner quickly points out, the physicians are on notice that you may not perform abortions at all under either statute, unless it's life-saving, that kind of thing. So you're on notice, the physicians are on notice there seems to be confusion on, well, what the penalty will be for that. Does your argument of due process apply to the penalty phase as well, or are you saying that it's unclear what's prohibited under Mr. Warner's interpretation?
Your Honor, I'm arguing the latter, that under Mr. Warner's interpretation, even within the text, there are some issues. For instance, 3622 allows an abortion in a medical emergency. 3603 would criminalize that very same act. Another example, ectopic pregnancy is defined as not even an abortion in Title 36. That is an act that would be criminalized under 3603. And finally, the most obvious one, which is an abortion by a licensed physician complying with Title 36, is allowed under Title 36 and is criminal under 3603, given the intervener's interpretation. The intervener also suggests that nothing suggests prosecutors will make arbitrary enforcement decisions. We're here today from the Pima County Attorney's Office with a different interpretation than the Yavapai County Attorney's Office. The former governor has had a different interpretation of the statutory scheme than the former Attorney General. And as the amicus briefs make clear, legislators who debated and voted on this bill have different interpretations. There is maybe never been a case where there is a potential for arbitrary enforcement such as this, and we're asking you today to resolve that for the statutory construction problems and issues that have been discussed, but also bearing in mind the constitutional problem that doctors and the people of Arizona need to be clear on what is illegal and what is legal. That's all. We did it in 3.5 minutes. Thank you.
Thank you, Mr. Brown. Mr. Warner.
Thank you. Title 36 and Section 13-3603 fit together in a very straightforward way. Up to 15 weeks, the termination must be life-saving. After 15 weeks, the termination must not only be life-saving, but immediately necessary to protect the mother. Not all life-saving terminations are immediately necessary, and petitioners never waived this argument. The text that the Attorney General quoted was from our petition, which said, for those life-saving terminations which constitute medical emergencies. We've exemplified this argument many times, including on intervener supplemental brief pages 13 and 14, and the Attorney General in briefing below mentioned it on pages 50 and 51. This application of law protects the mother while respecting the state's growing interest in protecting unborn children as they near viability. There's no conflict, and the limiting directives ensure this result. The legislature said Title 36 does not repeal Section 13-3603. It creates no right to an abortion and does not legalize any
Mr.
currently
Brown
unlawful.
points out the question of an ectopic pregnancy, which appears to be legal under Title 36, but appears to be an abortion illegal under 13-3603. What do we do with that?
Those terminations are always considered life-saving and would not be punishable under either 13-3603 or the 15 weeks law. Physicians note that those are emergency situations, so both exceptions in both laws would qualify.
But if you're a physician and you read 363322 subpart B, it wouldn't tell you that you can perform abortions up to 15 weeks as long as it's to save the life of the woman.
Well, certainly we would hope that the physician would read the entire text that the legislature has enacted, which includes Section 13-3603.
So the physician would have to read the Title 13 and the Title 36 provision together and just know that to know what's prohibited.
Of course, Your Honor, and this applies that way in certainly many contexts where conduct is regulated through multiple statutes. In fact, that's what physicians have to do right now, looking throughout the totality of Title 36 when understanding the contours of when it's appropriate to conduct a termination. I want to touch
Very few of
briefly.
them say it's okay to do it in this context, but criminalize it elsewhere. That's a little unusual.
I'm sorry, Your Honor, I don't think I understand that question.
Well, a physician who read 362322B would think that they could perform an elective abortion up to 15 weeks and would have to figure out elsewhere that it's criminalized in a different section of the statute. That's not the usual course of conduct.
Well, that provision only purports to regulate terminations after 15 weeks. It's our hope and expectation that physicians would look at the full code to understand what applies before 15 weeks, and that includes Section 13-3603. And that also triggers the construction directives, that Title 36 creates no right to an abortion and that it does not repeal Section 13-3603. And I want to be clear about that full line. Title 36 does not repeal Section 13-3603 or other abortion regulations. SB 1164 is the subject of that sentence, so it does not qualify as an other law in the predicate of that sentence. So I don't believe there's a conflict here, Your Honors. But if there is a conflict, the legislature has given it express direction. The pre-Roe law, Section 13-3603, is the winner if we have to choose between Section 13-3603 and Title 36, specifically SB 1164.
How do you respond to Mr. Gayona's point that the reference in the session law to or other laws regulating abortion refers to what he called the reason law, could also refer to the judicial bypass law as well, that you still would need to get permission of the minor or minor's parents or a court before 15 weeks. So why couldn't that language refer naturally to those types of scenarios, those types of statutes?
Yeah, Title 36 can regulate more conduct than Section 13-3603, but a repeal occurs when a formal law can no longer regulate the conduct that it once did. And as I mentioned earlier, those other laws certainly fully apply after the injunction below is lifted because they can apply in non-emergency situations. Because not all life-saving terminations are emergencies, those laws will have full vitality after the injunction.
Judicial bypass would never have full vitality because that's exclusively for elective abortions, aren't they?
I don't believe it's limited to that, Your Honor, under the text, because even in life-saving terminations, the legislature has required informed consent when the exigency allows. And this presumes that the life-saving termination is not an emergency and can trigger that law. In conclusion, I want to say that the text here fits the context. For over 100 years, Arizona has fully protected life from the moment of conception. Roe temporarily stopped that protection, but the legislature never gave up, reaffirming its commitment to Section 13-3603. We ask this court to reverse and fully remove the injunction below. Thank you.
Counsel, thank you for the arguments today on the supplemental briefing in this matter. The case is now at issue. An opinion will issue in due course, and the court will take a brief recess pending the next case.
Hello, everyone. So as you were just watching, the court proceedings just wrapped for a recess here. So we wanted to kind of go over some of the things that were talked about. We know a big focus was on just the difference between the territorial era law and then the new law saying that abortions would be okay up to 15 weeks. So obviously hearing a lot from the pro-choice and pro-lifers.
Yeah, and there was a lot of discussion specifically about prosecuting doctors, of course. So because under this 15-week law pro-life, they were saying, look, this has to be a life-saving measure for the first 15 weeks. Up until 15 weeks, yes, if it is a life-saving abortion that's performed. After that, it needs to be life-saving in an emergency. So the question is there, well, how do you enforce that with doctors? How can they determine, you know, if it is life-saving versus if it's not, and if it is an emergency, because they said life-saving doesn't necessarily mean an emergency. So there was a lot of kind of conversations about, you know, if we're going to be prosecuting the medical professionals who do provide these abortions, what would those terms look like? And they said, you know, that this new law does not establish the right to an abortion in the state of Arizona, and that was the big takeaway from pro-life, that it doesn't repeal the territorial era ban on abortion, and that abortion isn't a right in the state of Arizona, and it's always been a state that's protected, you know, unborn babies and life. So as far as pro-choice goes, that side was obviously a little bit different, so we'll let you kind of take it away on that.
Yeah, absolutely. We actually have team coverage today. If you were watching this morning, you saw Jack Cooper is live in Phoenix outside of the courtroom talking about those individuals that are either rallying out there, holding signs for both pro-life and pro-choice. But our very own Catherine Patterson, she was actually in the courtroom, so she's been sending us some notes as well. For those of you just now tuning in, Alliance Defending Freedom, they had one individual speaking for them today, one lawyer, and they were interpreting the 15-week law that it must be life-saving, as Anna was mentioned. mentioning, but not an emergency, saying not all life-saving treatment is immediately required. Planned Parenthood, on the other hand, they said that the 15-week law is an implied repeal of the 1864 territorial ban law that we keep talking about. They had 3 individuals talking for them, attorneys, and only 1 representative, again, for Alliance Defending Freedom. So something we're going to be talking about all day, going back to the history of really all of these laws taking place. Our own Bud Foster is going to be covering that. And then again, Catherine Patterson in Phoenix in the courtroom, Jack Cooper in Phoenix outside. So definitely make sure to tune in on air, online, and on our social media channels as we continue to update you throughout this really extensive case.
Yeah, and that's the thing, is that there's not going to be a decision made today, not immediately, so it could take some time. And up until then, people can still seek an abortion up until 15 weeks in the state of Arizona, so that's important to know. But expecting to hear from Chris Mays and Pima County Attorney Laura Conover here. They're probably speaking outside of the courthouse right now, so we'll have more from them, what they were saying. Also, the 2 sides outside. Obviously, there's people who are there this morning supporting Planned Parenthood. There's people who are there supporting the pro-life argument to it, and hearing both of their sides and why it was important enough for them to show up today, because it's such a, I mean, just heavy and weight issue. So both of the sides, Jack Cooper will be live in Phoenix at noon, so we'll have the latest from him. Be sure to join us online, and then just continuing coverage throughout the day. It's a lot. There's a lot that goes into it. So I think we tried to break it down the best way we could, but a lot of legal talk and a lot of things that I think most people, the general public, some terms that we just don't understand. The biggest thing is that up to 15 weeks, pro-life, their side is saying it needs to be life-saving, and pro-choice, they're saying it doesn't up until 15 weeks. So
a lot to unravel here. We're going to do it for you, give you the latest updates both on air, online, on our social media platforms. Make sure you download our 13 News app as well so you can get any push alerts throughout the day. But yeah, we will leave you all with that. Have a great day, everyone. Thank you for watching.